December 28, 1892, Robert J. and Joseph R. McLaughlin, who were then evidently owners of the lots on Collingwood Avenue, deeded lots 37 to 41 and 58 to 62. Inclusive, with the following restrictions. No residence shall be erected upon said premises, which shall cost less than $2,500, and nothing but residences shall be erected upon said premises. Said residences shall front on Helene, now Collingwood, Avenue, and be placed no nearer than 20 feet from the front street line. Property 438. July 24, 1893, the McLaughlins conveyed lots 17 to 21 and 78 to 82, both inclusive, and lot 98 with the same restrictions. Such restrictions were imposed for the benefit of the lands held by the grantors to carry out the scheme of a residential district, and a restrictive negative easement attached to the lots retained, and title to lot 86 was then in the McLaughlins. Defendant's title, through mean conveyances, runs back to a deed by the McLaughlins dated September 7, 1893, without restrictions mentioned therein. Subsequent deeds to other lots were executed by the McLaughlins, some with restrictions and some without. Previous to September 7, 1893, a reciprocal negative easement had attached to lot 86 by acts of the owners, as before mentioned, and such easement is still attached and may now be enforced by plaintiffs, provided defendants, at the time of their purchase, had knowledge, actual or constructive, thereof. The plaintiffs run back with their title, as do defendants, to a common owner. This common owner, as before stated, by restrictions upon lots sold, had burdened all the lots retained with reciprocal restrictions. Defendant's lot and plaintiff Sanborn's lot, next thereto, were held by such common owner, burdened with a reciprocal negative easement, and, when later sold to separate parties, remained burdened therewith, and right to demand observance thereof passed to each purchaser with notice of the easement. The restrictions were upon defendant's lot, while it was in the hands of the common owners, an abstract of title to defendants' lot showed the common owners, and the record showed deeds of lots in the plat, restricted to perfect and carry out the general plan, and resulting in a reciprocal negative easement upon defendant's lot and all lots within its scope, and defendants and their predecessors in title were bound by constructive notice under our recording acts. The original plan was repeatedly declared in subsequent sales of lots by restrictions in the deeds, and while some lots sold were not so restricted, the purchasers thereof, in every instance, observed the general plan and purpose of the restrictions in building residences. For upward of 30 years the united efforts of all persons interested have carried out the common purpose of making and keeping all the lots strictly for residences, and defendants are the first to depart therefrom. When Mr. McLean purchased on contract in 1910 or 1911, there was a partly built dwelling house on lot 86, which he completed and now occupies. He had an abstract of title which he examined, and claims he was told by the grantor that the lot was unrestricted. Considering the character of use made of all the lots open to a view of Ch12, Restrictive Covenants 439. Mr. McLean, when he purchased, we think he was put thereby to inquiry, beyond asking his grantor whether there were restrictions. He had an abstract showing the subdivision, and that lot 86 had 97 companions. He could not avoid noticing the strictly uniform residence character given the lots by the expensive dwellings thereon. And the least inquiry would have quickly developed the fact that lot 86 was subjected to a reciprocal negative easement, and he could finish his house and, like the others, enjoy the benefits of the easement. We do not say Mr. McLean should have asked his neighbors about restrictions, but we do say that with the notice he had from a view of The premises on the street, clearly indicating the residences were built and the lots occupied in strict accordance with the general plan, he was put to inquiry, and had he inquired he would have found of record the reason for such general conformation, and the benefits thereof serving the owners of Lot 86 and the obligations running with such service and available to adjacent lot owners to prevent a departure from the general plan by an owner of Lot 86. We notice the decree in the circuit directed that the work done on the building be torn down, if the portion of the building constructed can be utilized for any purpose within the restrictions it need not be destroyed. With this modification the decree in the circuit is affirmed, with costs to plaintiffs. Notes and questions. 1. In Sanborn, the Michigan Supreme Court cited McQuaid as one of the authorities for its judgment. Are there relevant differences between the two cases? 2. Could the plaintiffs obtain a money judgment for the McLean's violation of the restriction? 3. What gave the McLean's notice of the use restrictions? Would the result have been different if the McLaughlins included the restriction on only half of the initial grants? Why or why not? Property 440. 4. Is all property within a common scheme of development subject to the same restrictions? The answer depends on both the intent of the developer and notice to purchasers. If available documents or attributes of the property indicate that some lots within the subdivision have a different character than the rest, a court may find that the general restrictions do not apply. For example, in Sanborn, the court found that the common scheme attached to all lots on Collingwood, except lots fronting Woodward Avenue and Hamilton Boulevard. Why wouldn't those lots, if used for commercial purposes, undermine the common scheme? Consider Evans v. Pollock, 796 S.W.2d 465, Texas 1990. A developer subdivided a tract that included a peninsula of land surrounded on three sides by a lake. The developer sold all the lots fronting the lake but retained the property on the interior of the peninsula. All of the lakefront lots included an express covenant restricting use to single-family residences. The developer's retained property was on a slope overlooking the lake. The developer then sold the retained property to a buyer for the purpose of building a marina, private club, and condominium development. Lakefront property owners claimed that the proposed use violated an implied servitude. The court held that a common scheme of development existed, but only with respect to the lakefront lots. The lakefront deeds distinguished those lots from the developer's retained hilltop property. The lakefront lots included voting rights for collective governance of the lakefront lots, and the marked differences between the lakefront and hilltop lots, in both size and topography, reinforced that distinction. The court held that the restricted district need not be the whole subdivision nor include the whole retained tract. Purchasers of the lakefront lots were on constructive notice that the restricted district did not cover the hilltop lots. 5. The doctrine of implied servitudes invoked in Sanborn is not available in all jurisdictions. Massachusetts, for example, rejects the doctrine because it is inconsistent with the statute of frauds. See Houghton v. Rizzo, 361 Massachusetts 635, 639. 642, 1972. Massachusetts law does, however, permit the use of a common scheme of development to prove that one or more lots is an intended beneficiary of a promise. See Snow v. Van Dam, 291 Massachusetts 477, 482, 1935. Does the distinction between an implied burden, not permitted in Massachusetts, and implied benefit, permitted, make sense? Ch12, Restrictive Covenants 441. 2. Express servitudes. The third restatement, following general trends in the case law, significantly relaxes the common law's formal requirements for creating an enforceable servitude. Section 2.1 of the restatement provides in relevant part. A servitude is created. 1. If the owner of the property to be burdened a. enters into a contract or makes a conveyance intended to create a servitude that complies with the statute of frauds, or a recognized exception to the statute of frauds, or b. conveys a lot or unit in a general plan development or common interest community subject to a recorded declaration of servitudes for the development or community, or 2. If the requirements for creation of a servitude by estoppel, implication, necessity, or prescription, are met. A few features of the restatement approach are worth noting. The first is that the common law's requirement of horizontal privity of estate, that the covenant be created in an instrument that conveys some interest in real property between the original covenanter and the original covenantee, one, is eliminated. Under the restatement view, a contract containing the covenant is sufficient to bind successors, even if it passes no other property interest, so long as the parties intended the covenant to run with the land. Under this view, a covenant intended to bind successors is itself a sufficient interest in land. Second, there is a deep connection between covenants that run with the land and common interest communities, a property law institution that we will investigate further in a later chapter. Third, the 1. Thus, at common law, if B promised to use her land only for residential purposes in a deed from A to B, A and B would be in horizontal privity of estate with one another. However, if A and B simply entered into a contract whereby A paid B a sum of money in exchange for B's promise to use her land only for residential purposes, they would not be in horizontal privity of estate because no interest in real property passed under the contract. Property 442. Restatement elsewhere treats the common law requirement of notice as essentially a matter for the recording system, making the unenforceability of covenants for want of notice subject to the same rules as any other property interest. See Restatement 7.14. Finally, the restatement rejects, with heavy criticism, the common law requirement that a restrictive covenant touch or concern land. Restatement 3.1 CMT. A. Nevertheless, many jurisdictions continue to apply touch and concern doctrine, sometimes explicitly declining to follow the restatement approach. See note, touch and concern, the restatement, 3rd, of property, servitudes, and a proposal, 122 Harv. L. Rev. 938, 942-45, 2009. It is worth comparing the two approaches. Neponset Prop. Owners Association v. Emigrant Indus. Save. Bank. 15N.E.2D 793, NY 1938. Lehman, Judge. The plaintiff, as assignee of Neponset Realty Company, has brought this action to foreclose a lien upon land which the defendant owns. The lien, it is alleged, arises from a covenant, condition, or charge contained in a deed of conveyance of the land from Neponset Realty Company to a predecessor in title of the defendant. The defendant purchased the land at a judicial sale. The referee's deed to the defendant, and every deed in the defendant's chain of title since the conveyance of the land by Neponset Realty Company purports to convey the property subject to the covenant, condition or charge contained in the original deed. Upon this appeal, the defendant contends that the land which it owns is not subject to any lien or charge which the plaintiff may enforce. Its arguments are confined to serious questions of law. On this appeal we may confine our consideration to the merits of these questions, and, in our statement of facts, we drew indiscriminately from the allegations of the complaint and the allegations of the answer. It appears that in January, 1911, Neponset Realty Company, as owner of a tract of land in Queens County, caused to be filed in the office of the clerk of the county a map of the land. The tract was developed for a strictly residential community, and Neponset Realty Company conveyed lots in the tract to purchasers, describing such lots by reference to the filed map and to roads and streets shown thereon. In 1917, Neponset Realty Company conveyed the land now owned by the defendant to Robert Ch12, Restrictive Covenants 443. Oldner Dayer and his wife by deed, which contain the covenant upon which the plaintiff's cause of action is based. That covenant provides, and the party of the second part for the party of the second part and the heirs, successors, and assigns of the party of the second part further covenants, that the property conveyed by this deed shall be subject to an annual charge in such an amount as will be fixed by the party of the first part, its successors and assigns, not, however, exceeding in any year the sum of $4 per lot 20 × 100 feet. The assigns of the party of the first part may include a property owners association which may hereafter be organized for the purposes referred to in this paragraph, and in case such association is organized, the sums in this paragraph provided for shall be payable to such association. The party of the second part for the party of the second part and the heirs, successors, and assigns of the party of the second part covenants that they will pay this charge to the party of the first part, its successors, and assigns, on the first day of May in each and every year, and further covenants that said charge shall on said date in each year become a lien on the land and shall continue to be such lien until fully paid. Such charge shall be payable to the party of the first part or its successors or assigns, and shall be devoted to the maintenance of the roads, paths, parks, beach, sewers, and such other public purposes as shall from time to time be determined by the party of the first part, its successors, or assigns, and the party of the second part by the acceptance of this deed hereby expressly vests in the party of the first part, its successors and assigns, the right and power to bring all actions against the owner of the premises hereby conveyed or any part thereof for the collection of such charge and to enforce the aforesaid lien therefore. These covenants shall run with the land and shall be construed as real covenants running with the land until January 31st, 1940, when they shall cease, and determine every subsequent deed of conveyance of the property in the defendant's chain of title, including the deed from the referee to the defendant, contained, as we have said, a property 444. Provision that they were made subject to covenants and restrictions of former deeds of record. There can be no doubt that Neponset Realty Company intended that the covenant should run with the land and should be enforceable by a property owners association against every owner of property in the residential tract which the realty company was then developing. The language of the covenant admits of no other construction. Regardless of the intention of the parties, a covenant will run with the land and will be enforceable against a subsequent purchaser of the land at the suit of one who claims the benefit of the covenant, only if the covenant complies with certain legal requirements. These requirements rest upon ancient rules and precedents. The age-old essentials of a real covenant, aside from the form of the covenant, may be summarily formulated as follows: 1. It must appear that grantor and grantee intended that the covenant should run with the land. 2. It must appear that the covenant is one touching or concerning the land with which it runs. 3. It must appear that there is privity of estate between the promisee or party claiming the benefit of the covenant and the right to enforce it, and the promiser or party who rests under the burden of the covenant. The covenant in this case is intended to create a charge or obligation to pay a fixed sum of money to be devoted to the maintenance of the roads, paths, parks, beach, sewers and such other public purposes as shall from time to time be determined by the party of the first part, the grantor, its successors, or assigns. It is an affirmative covenant to pay money for use in connection with, but not upon, the land which it is said is subject to the burden of the covenant. Does such a covenant touch or concern the land? In truth, such a description or test so formulated is too vague to be of much assistance, and judges and academic scholars alike have struggled, not with entire success, to formulate a test at once more satisfactory and more accurate. It has been found impossible to state any absolute tests to determine what covenants touch and concern land and what do not. The question is one for the court to determine in the exercise of its best judgment upon the facts of each case. Clark, Op. Cit. 76. Even though that be true, a determination by a court in one case upon particular facts will often serve to point the way to correct decision in other cases upon analogous. Ch12, Restrictive Covenants 445. Facts. Such guideposts may not be disregarded. It has been often said that a covenant to pay a sum of money is a personal affirmative covenant which usually does not concern or touch the land. Such statements are based upon English decisions which hold in effect that only covenants, which compel the covenanter to submit to some restriction on the use of his property, touch or concern the land, and that the burden of a covenant which requires the covenanter to do an affirmative act, even on his own land, for the benefit of the owner of a dominant estate, does not run with his land. Nevertheless, some promises to pay money have been enforced, as covenants running with the land, against subsequent holders of the land who took with notice of the covenant. It may be inexpedient and perhaps impossible to formulate a rigid test or definition which will be entirely satisfactory or which can be applied mechanically in all cases. We should at least be able to state the problem and find a reasonable method of approach to it. It has been suggested that a covenant which runs with the land must affect the legal relations, the advantages and the burdens of the parties to the covenant, as owners of particular parcels of land and not merely as members of the community in general, such as taxpayers or owners of other land. That method of approach has the merit of realism. The test is based on the effect of the covenant rather than on technical distinctions. Does the covenant impose, on the one hand, a burden upon an interest in land, which on the other hand increases the value of a different interest in the same or related land? Even though we accept that approach and test, it still remains true that whether a particular covenant is sufficiently connected with the use of land to run with the land must be in many cases a question of degree. A promise to pay for something to be done in connection with the promiser's land does not differ essentially from a promise by the promiser to do the thing himself, and both promises constitute, in a substantial sense, a restriction upon the owner's right to use the land, and a burden upon the legal interest of the owner. On the other hand, a covenant to perform or pay for the performance of an affirmative act disconnected with the use of the land cannot ordinarily touch or concern the land in any substantial degree. Thus, unless we exalt technical form over substance, the distinction between covenants which run with land and covenants which are personal, must depend upon the effect of the covenant on the legal rights which otherwise would flow from ownership of land and which are connected with the land. The problem then is, does the covenant in purpose and effect substantially alter these rights? Property 446. Looking at the problem presented in this case, and stressing the intent and substantial effect of the covenant rather than its form, it seems clear that the covenant may properly be said to touch and concern the land of the defendant, and its burden should run with the land. True, it calls for payment of a sum of money to be expended for public purposes upon land other than the land conveyed by Neponset Realty Company to plaintiff's predecessor in title. By that conveyance the grantee, however, obtained not only title to particular lots, but an easement or right of common enjoyment with other property owners in roads, beaches, public parks or spaces and improvements in the same tract, for full enjoyment in common by the defendant and other property owners of these easements or rights. The roads and public places must be maintained. In order that the burden of maintaining public improvements should rest upon the land benefited by the improvements, the grantor exacted from the grantee of the land with its appurtenant easement or right of enjoyment a covenant that the burden of paying the cost should be inseparably attached to the land which enjoys the benefit. It is plain that any distinction or definition which would exclude such a covenant from the classification of covenants which touch or concern the land would be based on form and not on substance. Another difficulty remains. Though between the grantor and the grantee there was privity of estate, the covenant provides that its benefit shall run to the assigns of the grantor, who may include a property owners association which may hereafter be organized for the purposes referred to in this paragraph. The plaintiff has been organized to receive the sums payable by the property owners and to expend them for the benefit of such owners. Various definitions have been formulated of privity of estate in connection with covenants that run with the land, but none of such definition seems to cover the relationship between the plaintiff and the defendant in this case. The plaintiff has not succeeded to the ownership of any property of the grantor. It does not appear that it ever had title to the streets or public places upon which charges which are payable to it must be expended. It does not appear that it owns any other property in the residential tract to which any easement or right of enjoyment in such property is appurtenant. It is created solely to act as the assignee of the benefit of the covenant, and it has no interest of its own in the enforcement of the covenant. Ch12, Restrictive Covenants 447. The arguments that under such circumstances the plaintiff has no right of action to enforce a covenant running with the land are all based upon a distinction between the Corporate Property Owners Association and the property owners for whose benefit the association has been formed. If that distinction may be ignored, then the basis of the arguments is destroyed. How far privity of estate in technical form is necessary to enforce in equity a restrictive covenant upon the use of land, presents an interesting question. Enforcement of such covenants rests upon equitable principles, and at times, at least, the violation of the restrictive covenant may be restrained at the suit of one who owns property or for whose benefit the restriction was established. Irrespective of whether there were privity either of estate or of contract between the parties, or whether an action at law were maintainable. Casebro v. Mowers, 233 NY. 75, 80, 134 NE 842, 843, 21 ALR 1270. We do not attempt to formulate a definite rule as to when, or even whether, covenants in a deed will be enforced, upon equitable principles, against subsequent purchasers with notice, at the suit of a party without privity of contract or estate. There is no need to resort to such a rule if the courts may look behind the corporate form of the plaintiff. The corporate plaintiff has been formed as a convenient instrument by which the property owners may advance their common interests. We do not ignore the Corporate form when we recognize that the Neponset Property Owners Association, Inc., is acting as the agent or representative of the Neponset property owners. As we have said in another case, when Neponset Property Owners Association Incorporated was formed, the property owners were expected to, and have looked to that organization as the medium through which enjoyment of their common right might be preserved. Equally for all. Matter of City of New York, Public Beach, Borough of Queens, 269. NY 64, 75, 199 NE 5, 9. Under the conditions thus presented we said, it may be difficult, or even impossible to classify into recognized categories the nature of the interest of the membership corporation and its members in the land. The corporate entity cannot be disregarded, nor can the separate interests of the members of the corporation, page 73, 199 NE page 8. Only blind adherence to an ancient formula, devised to meet entirely different conditions, could constrain the court to hold that a corporation formed as a medium for the enjoyment of common rights of property owners owns no property which would benefit by enforcement of common rights, and has no cause of action in equity to enforce the covenant upon which such common rights depend. Every reason which in other circumstances may justify the property 448. Ancient formula may be urged in support of the conclusion that the formula should not be applied in this case. In substance, if not in form, the covenant is a restrictive covenant which touches and concerns the defendant's land, and in substance, if not in form, there is privity of estate between the plaintiff and the defendant. Notes and questions. 1. Does the touch and concern requirement lessen the potential for conflict between the law of restrictive covenants and the common law doctrines designed to preserve marketability of land, such as the presumption against restraints on alienation? 2. Is the court's resolution of the privity of estate issue consistent with what you've learned about corporate property? With the later New York case of Walkowski v. Carlton. 3. As with easements, restrictive covenants may be implied in particular circumstances, and they may arise by estoppel. The most common context for such a covenant by implication is a common scheme development, where purchasers acquire an interest in a parcel that is part of a community that appears to have commonly planned features such as residential uses of particular size and density. Such purchasers may be charged with notice of an implied reciprocal covenant restricting their parcels to uses consistent with the common scheme or plan. See Sanborn v. McLean, 206 NW 496, Michigan 1925. Restatement 2.11 and Illustrated 7, 2.14. Conversely, where the seller touts the benefits of such features to purchasers who buy in reliance on the seller's representations, the seller and his successors may be estopped from using the seller's retained land in a manner inconsistent with those uses. Indeed, such an estoppel may even serve as an acceptable substitute for the writing required under the statute of frauds. Restatement 2.9 to 2.10. 4. A historical note in the third restatement explains. At the beginning of the 20th century, 4 doctrines peculiar to servitudes law constrained landowners in the creation of servitudes: the horizontal privity doctrine, the prohibition on creating benefits in gross. Ch12, restrictive covenants 449. The prohibition on imposing affirmative burdens on fee owners, and the touch or concern doctrine. At the end of the century, little remains of those doctrines, which have gradually been displaced by doctrines that more specifically target the harms that may be caused by servitudes. Restatement 3.1, CMT. A. The touch and concern doctrine comes in for particular criticism in the restatement, which attacks the doctrine's vagueness, its obscurity, its intent-defeating character, and its growing redundancy. ID 3.2 CMT B. Accordingly, the restatement adopts a very different approach to the question of enforceability of restrictive covenants. Restatement, third, of property, servitudes. 3.1 Validity of servitudes, general rule. A servitude is valid unless it is illegal or unconstitutional or violates public policy. Servitudes that are invalid because they violate public policy include, but are not limited to: 1. A servitude that is arbitrary, spiteful, or capricious. 2. A servitude that unreasonably burdens a fundamental constitutional right. 3. A servitude that imposes an unreasonable restraint on alienation. 4. A servitude that imposes an unreasonable restraint on trade or competition. And 5. A servitude that is unconscionable. Notes and questions. 1. Is the rationale of the touch and concern requirement discussed in Neponset reflected in Section 3.1 of the restatement? If not, are there other features of Section 3.1 that serve the common law rules designed to ensure marketability of real property? 2. The restatement's invalidation of servitudes that impose an unreasonable restraint on alienation draws further distinctions between direct and indirect restraints. Direct restraints including overt prohibitions on lease or transfer, rights to withhold consent, options to purchase, and rights of first refusal are valid if reasonable, with reasonableness being determined by weighing the utility of the restraint against the injurious consequences of property. 450. Enforcing the restraint. Restatement 3.4. An indirect restraint is any other restriction on use that might incidentally limit the numbers of potential buyers or reduce the amount the owner might otherwise realize on a sale of the property, and such a covenant is valid unless it lacks a rational justification. ID 3.5 and CMT A. 3. In the late 2000s, as the financial crisis and the collapse of the housing market dealt crippling blows to the construction industry, one firm came up with what it thought was a clever solution that built on the same securitization model that powered the mortgage market in the run-up to the collapse. The firm, Freehold Capital Partners, advised real estate developers to insert a covenant in all the deeds to lots in their new housing subdivisions that would require the purchaser and their successors to pay a portion of the resale price to the developer on every subsequent transfer of the property. See Robbie Wellen. Home Resale Fees Under Attack, Wall STJ. July 30, 2010, available at http://www.wsj.com/article/SB100014240527433149051180. 2382. The plan was to securitize these private transfer fee payments, sell off slices of the right to the income stream from the transfer fees, and use the sale price of the securities to finance the construction of the homes that would be encumbered by the private transfer fee covenants. The scheme as conceived would not necessarily require the developer to retain title to any real property in the developments bound by these covenants. Realtors, title search agencies, legislators, and eventually the federal government mobilized against this business model. Many states passed statutes prohibiting or seriously restricting these private fee transfer covenants. See example text. Prop. Code 5.202, effective June 17, 2011. As of March 16, 2012, the federal agencies that repurchase or otherwise backstop many American residential mortgages will not deal in mortgages on properties encumbered by such covenants. Was all this legislative and regulatory action necessary? Would freehold capital partners' private transfer fee covenants be enforceable under the common law of restrictive covenants as set forth in Neponset? Under the restatement